Hello, wonderful followers and subscribers of Holy Ghost, and I hope this video finds you well. All right, guys, I've got two good, amazing news to bring to you. Now, today, Abuja High Court threatens 1. to jail Senator Akpabio, 2. Senator Nanda, that presides over the ethics committee, for suspending Natasha against the order of the honorable court. We are going to be reading together now on Thr Reporter. I saw it on Thr Reporter. I also saw it on Daily Post. All right. Now, before I bring the news to you, please, you got to watch it. I said I got two good news for you, two good news. So the second good news is this. Senate today, the Senate leader, Opeyemi, he cried that. He said Senator Natasha's allegation has been disrupting the National Assembly for the past 2 weeks. While listening to them, I said, I like this one, I like this one. Why won't allegation disrupt you guys if you guys have done the needful? Why won't allegation, I'm sorry, I thought this mic wasn't on. Why won't allegation threaten you guys when you couldn't just, give opportunity for fair hearing? So you guys will never have, like the Bible said, there's no peace for the wicked. So I like these two good news, guys. So we're going to be hearing from the Senate Majority Leader first. And after that, we're going to be hearing what the Honorable Court said regarding the suspension of Senator Natasha, the disobedience of the Senate. All right. So this time we see if Akpabio is too big to go to jail. All right. Please, before we delve into this, do me a favor by liking the video and please share. Thank you.
Before we go to the first business of the day, I'm writing under Order 41 and 51 to address a matter of urgent public importance. Mr. President, I don't know if I need to read.
You can go on.
Okay.
You are permitted.
Thank you, sir. Mr. President, I have no doubt that our colleagues are well familiar with this order. But for the record, again, Order 41, sub 1 of our rule says the matter of urgent public importance. The matter for discussion shall, if possible, be referred to the President of the Senate before commencement of the day's sitting, and the President of the Senate shall refuse to allow the claim unless he is satisfied that the matter is definite and urgent. And then Order 51 of our rules also talks about dispensing with notice. Notice shall not be dispensed with in the case of a motion or in respect of any other proceeding for which notice is required, except with the consent of the President of the Senate and the general consent of the senators present. The essence of Order 51 is that ordinarily, the issue of urgent public importance I'm about to raise ought to come on as a form of motion or notice. But Order 51 gives us the authority as a Senate to dispense with that notice, if in the judgment of the presiding officer and the consent of the single senators, the notice can be dispensed with. And the matter of urgent public importance that I want to discuss, Mr. President and distinguished colleagues, border on the kind of distraction that we have witnessed in the last 2 weeks as a Senate and as elected representatives of the Nigerian people, and the need for us to rest this matter so that we can concentrate on the mandate for which we were elected by the Nigerian people. And there's no doubting the fact, or there's no pretending about the fact that members of public have been genuinely interested in matters happening within this hallowed chamber in the last 2 weeks, especially with respect to the allegation by one of our distinguished members, home and abroad, as to whether or not she had been sexually harassed. And I feel it is important, once and for all, that we place on record where we are on this matter and rest the matter as an institution so that we can concentrate while we allow the court of law and any other agencies so constituted to deal with such matters to do their job. That is the basis of my writing on Order 41 and 51, and I will seek your permission and the consent of the Senate to go ahead. Please.
My distinguished colleagues, you've heard the synopsis of why is coming under two of these orders. I don't need to repeat that again. Is it your view to allow him to move on? Please, those in favor, please say aye. Those against say nay. The ayes have it. The leader will say you will continue.
Thank you, Mr. President, and I thank you, very distinguished colleagues. I begin by recognizing the right of members of public to subject what we do to utmost scrutiny. And I recognize the fact that it is the people that can criticize the government, because we're a part of the government. The government cannot criticize the people. Also, I recognize the fact that it is the people that can dissolve the government. Government cannot dissolve the people. And on that basis, I feel we owe the Nigerian public an explanation. Simply in this regard, this Senate, for the record, was never at any point between August 2023, when distinguished Senator Natasha Akpabio alleged to have been sexually harassed by the president of the Thr, up until the day that we announced on this floor that we were referring the petition brought by distinguished Senator Yemi Adaramodu with respect to Senator Natasha's flagrant disobedience to the rules and regulations of this House, of this Senate, was referred to the Senate Committee on Ethics, Privileges, and Public Petitions. In other words, none of us was ever told about any, sexual harassment situation. I want that to be clear. Secondly, I also want to make it clear to the public that the issue before us, as of the time we refer this matter to the Ethics and Privileges Committee, had nothing to do with sexual harassment. And some of the critics who have said this Senate allowed Senator Akpabio, the President of the Senate, to be a judge in his own cause and to preside over his own matter, need to be told, with all due respect, that the matter before us and on which Senator Akpabio presided over as the President of the Senate had to do with the motion that was referred to the Senate Committee on Ethics, Privileges, and Public Petitions. While we appreciate the concern of the public on this matter, I just want to emphasize that it is important that we also seek the understanding of the general public, that we were elected to serve the people. And we are guided, whatever we do in this chamber, we are guided by rules. And these our rules are also drawn pursuant to the Constitution of our country. So it's not a rule of men, it's a rule of law. It's not about some men trying to gang up against a woman or anybody. It's about ensuring that our rules are respected. That is the only way we can guarantee peace, we can guarantee law and order. That is the only way we can have an atmosphere in which we'll be able to do our job and serve the Nigerian people. Again, some of the critics have also said we have no right to even suspend a member of this parliament or this Senate. Again, I will leave that within the context of jurisprudence, as the courts will always speak to that. But it is very clear on our rules as to how far we can go. And we are not of the opinion that we are in breach of either the Constitution or any of our rules. Again, Section 60 of the Nigerian Constitution confers on this parliament the constitutional right to regulate its own procedure. And Section 1, subsection B of our rules book also makes it clear by reiterating that constitutional authority granted to us by Section 60 of our rule, of the Constitution, giving us the right to regulate our procedure. And suspension, as far as we are concerned, is the only alternative to the kind of anarchy that the nation witnessed in the past, where members of parliament had reasons to shout, to get physically engaged with each other, to engage in acts of violence, to tear each other's clothes, and do all manners of things. We are moving, and thank God that we are moved away from that. It also shows that democracy is growing, not sent as it might appear to be. And if there are people who still have issues with whether or not we can even suspend an erring legislator who have refused or who is refusing to work within the rules, I believe again, like I said, is for the court to continue to adjudicate, on that, unless the constitution is amended, taking away the authority for us to regulate our own procedure. And then, of course, with respect to the question of whether or not we are to, follow our rules, let me emphasize that the seventh schedule to our constitution, the seventh schedule to the Constitution of the Federal Republic of Nigeria, 1999, as amended, is clear, and it contains the oath of office that we are all made to take before we assume office as senators. And in that oath, we all swore that we will uphold this constitution, that we will make laws for the good governance of this country, and that we would also, in every step that we take, obey the rules and regulations of this Senate. We swore to that oath. And it is for this Senate as an institution to ensure that everybody abides by that oath. And again, outside of Nigeria or outside of this Senate, when it comes to our inter-parliamentary engagements, every one of those organizations, from Inter-Parliamentary Union to Commonwealth Parliament to African Union Parliament to ECOWAS Parliament, everyone is run on the basis of rules and regulations drawn from the protocols establishing those organizations. And that was why the Inter-Parliamentary Union president, 2 days ago, after listening to our colleague, the single Senator Natasha, had to also go by their rule. One, that the issues that she raised was outside of the agenda of the meeting. Number two, having heard her, it will also be important to listen to the other side, because they are all guided by rules. And also, let me emphasize that Section 1, Sub 1 of the law establishing the Inter-Parliamentary Union itself makes it clear that membership of IPU shall be on the basis of national parliamentary organization. In other words, there are no individual members. It is parliament of sovereign nations.
According to Thr reporters, Abuja High Court threatens to jail Senate President Akpabio over Natasha's suspension. Justice Obiora Of Abuja had previously granted an ex parte order on March 4th restraining the Senate Committee on Ethics, Privilege, and Public Petitions from conducting disciplinary proceedings against Akpabio Uduaghan. The suspension of Senator Natasha Akpabio Uduaghan, representing Kogi Central, has taken a new turn as she filed a contempt application against Senate President Godswill Akpabio for allegedly disobeying a valid court order. In suit number FHC/ABJ/CS/384/2025, Senator Akpabio Uduaghan is listed as the plaintiff, while the clerk of the National Assembly, the Senate of the Federal Republic of Nigeria, the President of the Senate, and the Chairman of the Senate Committee on Ethics, Privilege, and Code of Conduct, Senator Nada Imaswen, are named as the first to fourth defendant and alleged what? Contempt minors. Okay. Justice Obiora Of Abuja had previously granted an ex parte order on March 4 restraining the Senate Committee on Ethics, Privilege, and Public Petitions from conducting disciplinary proceedings against Akpabio Uduaghan. Justice Of Abuja, in the ex parte application supported by a 25-paragraph affidavit heard by Natasha's legal team on March 3, 2025, and argued on March 4, specifically said, an order of this honorable court is made declaring that any actions taken during the pendency of his suit is null and void, and of no effect whatsoever. Despite the existence of the court order, which was widely publicized, the Senate proceeded to suspend Senator Akpabio for 6 months over alleged misconduct. The Senate also directed that her office be sealed and ordered her to hand over all Senate property in her possession to the clerk of the National Assembly for the duration of the suspension. The decision followed the adoption of a report by the Committee on Ethics, Privilege and Public Petitions chaired by Senator Nada Imasue, representing Edo South. The committee initiated disciplinary proceedings after the February 20 incident between Senator Akpabio and Senate President Akpabio. In response to the Senate President for the court order, Akpabio, through her lawyers, filed a Form 48 notice of disobedience of court order at the Federal High Court in Abuja. The application, brought under Section 72 of the Sheriff and Civil Press Act 2004 and the inherent jurisdiction of the court, serves as a notice of consequence of disobedience to the court order issued on March 4, 2025. The court document dated March 7 and signed by the registrar was obtained by Sahara reporters on Thursday. It reads, "Take notice that pursuant to Section 72 of the Sheriff and Civil Process Act, your willful disobedience of the order of this honorable court, quorum, Honorable Justice O.A. Egwatu J., made on the 4th day of March 2025, renders you liable for contempt of court, for which you may be committed to prison unless you comply with the said order. Take further notice that despite being duly served with the entreated order on the 5th day of March 2023, you, the defendant committee, have deliberately and contemptuously disregarded his breaching these directives proceedings with acts in flagrant defiance of the authority of this honorable court. A copy of the said order is annexed hitherto for ease of reference." Okay, all right, that's all. What's your take on this, guys?